Business owners, have you heard of the Connelly case from the Supreme Court? The recent ruling is significant and may impact companies' buy-sell agreements and succession plans. And yet, many owners may not be aware of the major implications or understand the potential increase in tax burdens for their business continuity strategies. Today, we'll break it down for you right here on UBS Trending. Hi everyone, I'm Bianca Benedetti-Fang, and we are back with Chris McCullough and Patrick Harrington to talk more life insurance, business succession planning, and specifically how the Connelly case from the Supreme Court may have some owners going back to the drawing board. So Patrick, from an insurance perspective, how is this going to impact business owners, and what is the headline here?
So if I can set the stage for the conversation here, the headline is that the often used buy-sell agreement was placed under a microscope with the recent Supreme Court decision in the Connelly case. So specifically, it answered questions around life insurance proceeds, the business valuation, and the redemption obligation within a buy-sell agreement. So I think for me, the key takeaway here, and I'm excited to hear Chris's commentary, is that if you have a buy-sell agreement, now is an opportune time to be in touch with your advisor, be in touch with your insurance resource to dive a little bit deeper on the plan in place.
All right, perfect. And absolutely, I think that there are a lot of ramifications here. Chris, from a financial planning side, what would you say some of the implications are? Because I know a lot of business owners leverage these buy-sell agreements for their insurance policies.
So I think the headline from this case is that a redemption requirement for a company to buy the shares of a deceased shareholder's holdings from their estate does not create an offsetting liability against the assets of the business. And so what does that mean in practice? Well, in this situation, we had two brothers. They were both shareholders in a building supply company. And like many families, they put together an agreement, a buy-sell agreement, to make sure that the business stayed within the family upon the death of one of the brothers. They funded this buy-sell agreement, or the requirement to purchase the shares, by buying life insurance, holding that life insurance in the corporation, and then ultimately buying the shares back from one of the brothers' estates.
Okay, and that's a very commonplace practice, right?
It's very common practice, yeah, absolutely. So I guess fast forward a couple of years, one of the brothers passes away, and the company then goes and buys the shares from the deceased brother. They buy it for $3 million. They also have to file an estate tax return. And so they value the business at about $3.5 million. The insurance policy was also about $3.5 million. So they're just around $6.5, $7 million for their estate tax filing. And this is where things got a little tricky with the IRS. The estate for the deceased brother, they deducted out the purchase price, the $3 million that they paid the estate, from the market value of the business. And so the IRS said, I don't think you can do that. They had a little dispute. It made its way through the court system, and ultimately the Supreme Court agreed with the IRS and said, you're right, you can't subtract out that liability.
Okay, got it. And so for business owners that may potentially find themselves in a similar situation, what should they be doing? What should they potentially be thinking of, particularly from a planning perspective?
Yeah, there's a lot of different opportunities and options for them to review. The biggest thing is reviewing their buy-sell agreement. Take it out. There's a couple different buy-sell agreements. Maybe I could turn it to Patrick. He might, be able to fill us in a little bit on, the difference between a cross-purchase agreement and an entity purchase agreement, because I think that's the biggest place where that trips up owners.
Absolutely. I would love to know as well.
Sure. Ultimately, the answer is going to be a little bit different for each business owner, but I think there's a few considerations, and I'll do my best not to get too technical here. So I think one consideration is a cross-purchase plan. So in a cross-purchase plan, you're going to remove the business entity altogether from the life insurance payout by having each business owner own a life insurance policy on each other. So in doing so, you're removing some of the valuation issues that Chris just spoke about within the Connelly case. So I think this is a nice option. The caveat here is very quickly with multiple business owners, it can become a logistical challenge to implement and write all of those insurance policies on multiple business owners, but a good option nonetheless.
Okay, so for a smaller partnership agreement, right, maybe 2, maybe 3 partners in the business, that
Exactly.
is a really great way to mitigate some of the potential ramifications.
Exactly. And then the other consideration, maybe it's a larger business, perhaps they consider what's called a insurance LLC. So this is a business continuation partnership that's structured as a separate LLC to hold one insurance policy on each business owner. So the value here is some simplicity by having less insurance policies, but also addressing, again, the valuation issues that came to light in the Connelly decision. So ultimately, the best path forward may be to do nothing at all.
Okay, and that absolutely makes sense. I think all businesses are unique, and so the solutions and the strategies that are needed are never really going to be one size fits all. So thank you for that, Patrick. Really appreciate it, and I absolutely agree that periodic review is key. And Chris, just to close us out, I think there will be many business owners that maybe have never dealt with this before and don't know where to start. So what are some of the questions that they should be asking you and your team as they're considering the potential implications of the ruling?
So I think what UBS is really good at is helping business owners determine what solutions fit their problem set. So for example, we heard earlier in this case, it was 2 brothers, small business. Their goal was to maintain control within the family. There are certain solutions that might solve that problem. A larger business, let's say a medical practice, multiple doctors, one of those doctors passes away, they have a different problem where they need business continuity, but they also need to probably buy that partner's estate out of his share, right? And so there's different complexities with having multiple shareholders compared to maybe just 2 shareholders. And what happens is the questions that come up are, how do you fund the insurance policy? Who owns the insurance policy? Who's on the hook for counting the insurance policy as part of their estate? And these are things that UBS and UBS financial advisors can help clients work through, but they need to have that discussion and really drill down on that topic.
That's perfect, Chris. And I'm sure it even helps for some of these business owners to have those conversations up front before they have an incident where they really need to address it. And your team is so fantastic in that way. So thank you both so much for joining us today. For more on this topic and advice to help owners thrive at every stage of business growth and exit, please reach out to your UBS financial advisor. And for more episodes, please visit ubs.com/views. You can also give us a follow on Instagram at UBS Trending. And we're on LinkedIn, YouTube, Facebook, and X, formerly known as Twitter. And as always, if you have any questions about your portfolio, please speak with a financial advisor. From New York, I'm Bianca. Have a great day, and remember to keep your eyes on what's trending.